So, what happens when the will of an entire elected legislature hits a roadblock? A roadblock put up by just one single appointed official. Well, a recent Supreme Court opinion has totally redefined this power dynamic. And according to the editorial we're breaking down today, it could fundamentally shift the balance of power in India's federal structure.
And that really is the core question, isn't it? Can one person who isn't even elected effectively put the brakes on the work of an entire elected assembly? You'd think the answer would be a simple no way. But the constitutional reality, well, it's a whole lot more complex. All right, to really get our heads around this, we have to go straight to the source, the Constitution itself. See, a governor's power isn't unlimited. It's actually defined by a very specific set of rules. And there's one article in particular that's right at the heart of this entire debate. Yup, everything hinges on Article 200. You can think of it like a constitutional checkpoint for every single law a state tries to pass. When a bill lands on the governor's desk, this article gives them a few very specific options. So what can they actually do? Well, option 1, they can give assent, and boom, the bill becomes law. Simple enough. Option 2, they can withhold assent, basically sending it back to the legislature with a note saying, hey, maybe you should rethink this. And then there's option 3. They can reserve the bill for the president's consideration, which kicks the whole decision up to the national level.
But here's where it gets really tricky. The Constitution says the governor has to act as soon as possible. Now, what on earth does that mean? A week? A month? A year? For decades, this super vague phrase has been a major source of conflict, and the Supreme Court's latest take that this phrase is just too elastic to enforce any real deadline is the key to this whole story.
And that brings us to the core drama here, a really stunning reversal by the Supreme Court. Just when it looked like a progressive judgment had finally sorted out this whole issue of delays, it was suddenly overturned, creating a brand new and much more uncertain landscape for state lawmaking. You know, you can see this has been a debate for a long, long time. The framers of the Constitution actually went out of their way to remove the governor's discretion that existed way back in 1935. Over the years, people called for clarity. Then, earlier this year, a landmark judgment finally set a clear timeline. But just a few months later, completely reversed. You see, that April judgment really felt like a breakthrough. It gave governors a 3-month deadline and even introduced something called deemed assent, which meant if they didn't act in time, the bill just automatically became law. It seemed like the perfect fix for legislative gridlock. And when you put these two rulings side by side, the difference is just, wow, it's stark. The April decision was all about speed, about making sure the legislative will was respected in a timely way. The new opinion completely rejects that, saying courts can't just impose deadlines on the executive. It's a fundamental shift from prioritizing laws getting passed to prioritizing a very strict separation of powers. And this is the core reason the court gave for its decision. It argued that trying to force a governor or the president into a rigid, one-size-fits-all timetable would be judicial overreach, the courts stepping into the executive's territory. In their view, every bill is different and needs a flexible approach, not some uniform deadline. Okay, so what does this all mean in the real world? What actually happens when there are no timelines? This creates a whole new reality for state legislatures. Let's explore the practical consequences of giving someone power, but without a clock. The editorial we're looking at highlights what it calls a brand new legislative loophole. Here's how it could work. The Assembly passes a bill, the governor sends it back. The Assembly, determined, passes it again. Now, that used to be pretty much the end of it, but the new opinion says that even at this stage, the governor can still turn around and reserve the bill for the president. And this is what leads to what the editorial calls the presidential dead end. Because once a bill is sent to the president, it pretty much enters a constitutional black hole. There is no deadline for a decision, the president doesn't have to answer to anyone about it, and the state assembly, they have absolutely no recourse. The bill can just sit there forever. Now, the court did throw in a little caveat. It said governors can't engage in prolonged and evasive inaction. That sounds like a pretty good safeguard, right? But the editorial argues that it's a protection without any real teeth. So what's the fix for this so-called prolonged inaction? Get this, the state government has to go back to court. They have to launch a whole new, lengthy legal battle just to prove that the delay is unreasonable, a word that has no clear definition. This whole process puts the entire burden back on the state, creating a massive new hurdle to getting a law passed. At the end of the day, this entire issue boils down to a fundamental conflict. It's a classic clash between two core principles of the Indian Constitution: the rights of states and the power of the central executive. On one side of the scale, you have the separation of powers. This was the court's main justification, that the judiciary shouldn't step on the executive's toes. But on the other side, you have federalism, the whole idea that states have a right to govern themselves. The editorial's central argument is that this new ruling tips the scales heavily in one direction, at a huge cost to the other. So what's the bottom line for state governments? Well, according to this editorial, the picture isn't pretty. This ruling leaves them seriously weakened. They've lost any real way to challenge delays, they've lost that deemed dissent safety net, and they have no clear path forward once a bill gets kicked up to the president.
And that leads to this really powerful concluding thought from the source. The argument is that by focusing on a very literal, elastic interpretation of a phrase like "as soon as possible," the court may have ended up undermining the much broader constitutional spirit of federalism and representative democracy.
And so we're left with this fundamental, nagging question. In a democracy, who should get the final say? The people's elected representatives or an appointed official holding a constitutional check? The Supreme Court's latest ruling has given its answer, but for the states and for the federal structure of India, it's pretty clear this debate is far from over.